Mr. Jenkins, sorry we're boring you, but if I hear you yawn out loud again, it's not going to be good. Sit up, pay attention, wake up. This is all about you today. Okay, so in each of these motions, they were second amended motions to revoke unadjudicated probation. Mr. Jenkins pled true in each of those to counts 1, 2, 3, 4, 9, 10, 12, 13, 14, and 18 on probation for theft of a firearm in each case, which are state jail felonies. Is everyone ready to proceed?
We are, Your Honor. I'd like to put on the record what the offer is, and just for him to reject the offer,
Sure.
if I may.
Yes.
Your Honor, it's my understanding that the offer is 20 months on the motion to revoke probation and 10 years on the ag robbery case with a dismissal in the fraud case. And Mr. Jenkins has indicated that he wants to reject that offer. I've indicated to him that the state is likely going to file a motion to stack those sentences in all 3 cases, and he's expressed to me that he wants to reject that.
Mr. Jenkins, so I want to make sure you understand, you've talked to Mr. Parker about all of that, is that correct? And we'll get through today these 2 MTRPs, and then whatever happens on those after that, that aggravated robbery and the fraudulent use or possession of identifying information. I already did it. Those will be set for trial. If you go to trial and a jury finds you guilty, then the state can request that I stack whatever punishment you get then on top of what you get today. Do you understand? And you want to reject that and go forward with this hearing, and then we'll figure out a trial date for other cases. Is that what you want to do? I'm sorry?
Yes.
Okay. And so, Mr.
All right, guys. This courtroom hearing started with a defendant who seemed completely disconnected from the seriousness of his situation. Before the proceedings even got underway, the judge had to call him out for yawning and appearing bored while sitting in court. And trust me, that did not leave a good first impression. As the hearing continued, the court reviewed multiple probation violations connected to firearm theft cases. Then came a major turning point. The defense attorney explained that prosecutors had offered a deal that would have resolved several cases at once, including an aggravated robbery charge and a fraud-related offense. However, despite being warned about the risks, the defendant chose to reject the offer. The judge carefully explained that if he later went to trial and was convicted, prosecutors could ask for additional sentences to be stacked on top of whatever punishment he received that day. Yet even after hearing that warning, the defendant decided to move forward.
Parker, I will allow you to go forward with argument on punishment.
Your Honor, I mean, this is on motions to revoke probation. And I mean, the only thing I have to offer is that my client is set in jail. And obviously I'm not going to argue as to the facts of the other alleged crimes. Just his probation here is that drugs has been a problem for him, which his probation officer has admitted to. And my client is set in jail for a considerable amount of time, which he's expressed to me, he's expressed to his probation officer. He's realized, I mean, he's been there for several months, and he's learned that the people that he hangs around aren't the right people for him. He wants to do better in life, be there for his family, and I think some type of treatment and to allow him to continue on probation is the best thing. Otherwise, I would just defer to the court their decision.
Thank you, Mr. Parker. Mr.
Judge,
Smith?
Based on his activity in the jail, based on his activity when he's not in jail, all of the allegations that were found true, all of the new crimes that have been committed, continuing him on probation after having successfully completed both tracks of ISF, just not be appropriate. We ask that you find him guilty, revoke his probation, and sentence him to 24 months in the state jail on each case.
Now this is where the battle over punishment began. The defense attorney argued that drugs had played a significant role in the defendant's problems and suggested that treatment would be more effective than sending him back to jail. According to the defense, The defendant had spent months behind bars reflecting on his mistakes and had supposedly realized that the people around him were leading him down the wrong path. His lawyer claimed that he wanted to change, support his family, and become a productive member of society. But prosecutors saw things very differently. They pointed to a long list of probation violations, new criminal allegations, and misconduct both inside and outside of jail. From their perspective, the defendant had already been given numerous opportunities to turn his life around. Instead of improving, they argued that he continued engaging in criminal behavior. Because of that pattern, prosecutors asked the judge to revoke probation entirely and impose the maximum state jail sentence available.
Thank you, Mr. Smith. So, Mr. Jenkins, one of the things that Mr. Parker said, and that a lot of especially younger offenders come in here to say, is that they're hanging around the wrong people, and that's part of the problem. And what I typically see, and more, is that what I think you are as well, is you are the wrong person, right? I mean, nobody's forcing you to do anything, and everybody wants to do this and say that somebody else is at fault for being a complete menace in our community, running around with guns, stealing from people, being part of a group that ends up shooting someone, that terrorizes a family in the middle of the night. You didn't have to be there, so you are the bad person. My only regret here truly is that I only have 2 years to give you, and that's not going to keep you off our streets long enough. It's ridiculous that you were given the opportunities that you were given when you got this probation. And I know what I said to you, because I say it to everyone, especially you young ones. I'm sending you to ISF so that you can learn how to get out and be successful on probation. And you got out and you just running around with stealing and guns and shooting and all the bad things like you're living in the Wild West. In cause number 22-39541, I'm going to find, again, that you entered your pleas of true to counts 1, 2, 3, 4, 9, 10, 12, 13, 14, and 18 freely and voluntarily. In addition,
All right, guys, this was the moment the judge absolutely unloaded on the defendant. When the defense blamed bad influences and the wrong crowd, the judge wasn't buying it for a second. In one of the harshest speeches of the hearing, she rejected the idea that other people were responsible for his choices. Instead, she told him something brutally direct. He wasn't surrounded by bad people, he was the bad influence. The judge pointed out that nobody forced him to carry guns, steal property, participate in dangerous criminal activity, or associate with violent groups. According to the court, every decision had been his own. She described the defendant as a menace to the community and expressed frustration that previous opportunities for rehabilitation had completely failed. What seemed to anger her most was the fact that he had already been given special programs and treatment designed to help young offenders succeed. Yet despite those chances, he returned to exactly the same criminal behavior.
in cause number 22-39210, find that you entered those same pleas of true freely and voluntarily. In each of those cases, also make the findings that counts 5, 6, 7, 11, 15, 16, 19, and 20 are true. Find sufficient evidence at this time to find you guilty, and in cause number 22-39541, find you guilty of theft of a firearm. Sentence you to a term of 24 months in the state jail prison. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 22-39210, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Give me just a second. I need a certification. Thanks. I'm going to hand you in just a minute. You'll need to sign it, and then I'll give you a copy of a document called your Certification of Right to Appeal. You do have some rights to appeal this decision and these findings today. You can talk to Mr. Parker about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can also talk to Mr. Parker. What we'll do now is move those two, the ag robbery and the new fraudulent use or possession of identifying information. We'll put it on one announcement docket. If it's not worked out at that point, then we'll get those set for trial as quickly as possible.
Final moments of the hearing, the judge delivered the punishment. After reviewing all of the probation violations and evidence presented before the court, she officially revoked probation and found the defendant guilty in both firearm theft cases. The sentence was straightforward but severe, 24 months in state jail for each case, along with credit for time already served. But the consequences didn't stop there. The judge also informed him that, under Texas law, he would no longer be eligible to legally possess firearms or ammunition. She carefully explained that violating those restrictions in the future could result in entirely new criminal charges. Even as the sentencing concluded, more legal trouble remained ahead. The aggravated robbery and fraud-related cases were still pending and could eventually proceed to trial. The judge made it clear that if those cases weren't resolved, the defendant would soon find himself back in court facing another battle, one that could potentially carry even more serious consequences than the sentence he received that day.